Hey there, estate planning attorney Paul Rabalais here, and in this video, we're going to talk about 12 mistakes that executors make and how to avoid those mistakes. So if you've been named as an executor, congratulations, or if you've named someone else as the executor of your estate, or if you're considering naming someone as the executor of your estate, you're going to want to watch this video because this is going to lay out the 12 most common mistakes that executors make. And you either can avoid those mistakes if you are an executor, or you can appoint someone who's not likely to make these mistakes. All right, so I will start by saying the probate process in general gets a bad rap, kind of justifiably so. A lot of bureaucracy, a lot of red tape, lawyers involved, judges involved, lots of delays that contribute to the probate problem. But oftentimes a major problem in getting an estate complete is executor problems. So I'm going to go through 12 mistakes that executors make and how to avoid them, and we're going to jump right in. We're going to go kind of fast, and quite frankly, I think what I'll do is I'm going to describe and tell you in the video how to avoid them, but in the description below, I'll list out just real quick the 12 mistakes. The first one, just delay. Probate takes a long time, lots of steps, lots of delay. And when the executor delays, it just adds to the overall delay of probate, which frustrates everybody. Think about it. If an executor has maybe 20 tasks to do as part of settling an estate, and in each task, they're busy, they got other stuff to do. So in each task that they have to do, they kind of mess around for about 3 weeks. So each task is delayed for 3 weeks. Well, that's just the executor delay right there is going to add a year to the probate process, not to mention all of the other delays that are inherent in completing a probate. So make sure you stay on top of things if you're an executor. Number two is paying out the funds too early. Heard so many times before. Start a probate, get the call. Hey, Paul, I'm the executor. My sister, she's kind of in a jam, and she wants to know if she can have some of her inheritance. So here's what I'm going to do. I'm going to there's some cash in the estate, and there's 4 of us heirs, and my sister's really in a jam. So we're going to just distribute all the cash in the estate, and we'll worry about all the other assets later. And then come maybe weeks, months, or even years later, there's that cash is needed for the estate. It's needed to pay debts of the estate. It's needed to pay property tax on a piece of property in the estate. It's needed to pay taxes that were due perhaps on a final income tax return. It's needed to pay attorney's fees. It's needed to pay executor fees. So, and then what do? Then you have to maybe unnecessarily liquidate other assets, or in circumstances, you may have to go back to those 4 people that you distributed cash to and say, hey, you know what? I didn't realize we need that cash. And so can you give it back to the estate because we need it to move things along on the estate settlement process? And quite frankly, if you distributed it to a sister who was kind of, quote, in a jam, you think she's going to have that cash? No, she used it to get out of her jam. So big problem if you pay out funds too early. Number 3 is the portability election. My guess is not making the portability election is the mistake. My guess is that unless you're an estate attorney who's fairly well versed in the estate tax aspects of estate settlements, you probably have no idea what portability is. But lack of failing to make the portability election might be the biggest mistake. It could be the most costly mistake that an executor could make. I'm going to link you to a video right up there that talks about the portability election. And that video was made before we have this new administration, which could cause the problem to be even worse. The main concept behind portability is when the first spouse dies. You have a married couple, first spouse dies. The executor of the first spouse to die's estate can file an estate tax return, even if it's not necessary. Make this portability election so that the surviving spouse not only gets the surviving spouse's estate tax exclusion amount, but they also get the first spouse to die's unused estate tax exclusion amount. And with the new administration and the possibility of the estate tax exclusion amount for that surviving spouse going down to maybe, who knows, maybe $3 million or so, It may be a big, big mistake not to make the portability election within the timeliness of 9 months after the death of the first spouse to die. So again, watch the video that I've linked and you'll learn everything you need to know. Mistake number four, not following the terms of the will. I've had people come to me and say, you know what, I'm the executor. Mom told me she wanted each of the grandchildren to get $10,000 each. There's 12 grandchildren, even though she didn't get around to putting any of that in her formal legal documents. So since I'm the executor and I've got control of Mom's cash, I'm just going to go ahead and make sure I honor her wishes and pay out the $10,000 to each of those grandchildren. Not so fast. That's a problem, because the people who would have received that $120,000, they're likely to say, where's my money? And under what authority do you have to give my money to somebody else? And then you're going to be stuck saying, well, that's what Mom told me, but you had no basis for doing that based on what Mom told you. You got to follow the terms of the will. Mistake number 5, failing to provide all of the asset information. If there's one executor mistake that probably irks me the most, it's this one. It's we complete an estate, so much paperwork, so much delay, so much hassle. We finish it, and then we know we're done. We're like, whew, okay, we finished that one. And then here comes the email. Here comes the phone call. You know what, Mr. Rabalais? We didn't know it, but we found this additional bank account that my father had. Or we found these shares of stock that my mother had, and we didn't even know, so we didn't tell you about them. Or, you know what, Mr. Rabalais, we forgot to tell you about this piece of property that's been in my mother's family for years, and now they're trying to sell it, and I realize the estate is over. What do we do? And at that point, I want to just kind of shoot somebody, because now we've got to kind of go back in, start all over as to that piece of property, that asset, that account, those shares of stock. Would have been so much easier to have just addressed it with all of the other assets in the estate. But now that things are concluded, we got to go back, we got to reopen. Make sure you provide all of the appropriate kind of asset information. Do an exhaustive search of records and the mail that's coming in and the 1099s and the tax returns, so that you can provide all that asset information and not have to go back and redo things. Mistake number 6, the executor's failure to communicate. There is, just trust me on this one. There is something about an executor failing to communicate with the heirs that makes the heirs extremely nervous. So, Paul, my brother is the executor and he's just not communicating. I'm starting to wonder whether he's skimming some things off the top, or it could be even worse. Paul, my sister is the executor and she is not returning my texts, my calls, my emails, and that makes people fear the worst and makes them all lawyer up. It can just ruin relationships moving forward. On the other hand, when an executor communicates openly with all of the heirs, and it's so easy to do with email these days and scans and all that, and executor sends out periodic emails. Here's all the assets. Here's the statements of the financial accounts of the person who passed away. Here's what I know. Here's our plan moving forward. It just makes all of those heirs relax and say, okay, we got this under control. The executor is providing, all of the information that they have. They're not trying to hide anything. I know this is going to be done right. So really make sure you communicate. Executor mistake number 7 is confusing probate assets with non-probate assets. Give you a couple of examples. IRAs, as long as they have designated beneficiaries, which they do, 99% of the time, unless somebody fails to designate beneficiaries, it's not an asset that the executor has to deal with. It doesn't go on any of the probate lists of assets. It's handled all outside of the probate. The designated beneficiaries complete some paperwork with the financial institution wherever that retirement account or IRA is held, and the financial institution will deal with those beneficiaries directly. That's handled outside of probate. Life insurance, it gets tricky with life insurance. Nobody ever understands it. So if Dad had a life insurance policy and he named his 4 kids as the beneficiaries, then when Dad dies, it's not a probate asset. Then the 4 kids will work directly with the life insurance company, and the life insurance company will cut checks to the 4 beneficiaries. That's all outside of the estate. However, with life insurance, sometimes Dad could be an owner of a policy, but he's not the insured on the policy. Maybe he had a policy on his wife, or maybe he had a policy where the kids were the insured and Dad's the owner. Now that life insurance policy is part of Dad's probate estate because he was the owner and he was not the insured, so we've got to list it so that as it goes through the probate process, the ownership of that policy gets transferred to Dad's appropriate heirs. So a lot of confusion out there about probate and non-probate assets. Mistake number 8 is not collecting estate funds in an estate account. Have had it told to me numerous times before. You know what, Mr. Rabalais? I was a signer on Mom's account, and after Mom died, I was worried that the bank might freeze the account. So I took all the funds out of Mom's account, and I put all those into my account, is what somebody might say. Don't do that. So it just looks bad, even with the best intentions. That looks bad. So in addition to that, there's some pretty stiff penalties. At least there's one in my state where I work in Louisiana that says an executor shall deposit all the estate monies in an estate account. And if they don't, then a judge can render a judgment against the executor personally for 20% interest annually on those funds that were not deposited into an estate account. And the fact that they don't deposit the estate funds into an estate account is also grounds for the executor to be dismissed from office. So make sure you collect funds in an estate account. Don't put them in your own account, just kind of for safekeeping and for holding. Executor mistake number 9, getting help from friends instead of professionals. This is the old, you know what, Mr. Rabalais, my uncle died. He named me as the executor, and my second cousin's friend's stepfather is a lawyer, and he had handled a divorce and a car wreck for the family, and he seemed to do a pretty good job. So we called that lawyer, because he's a lawyer, to handle the estate. And you know what? Boy, was he in over his head. And then he finally kind of admitted that he made some mistakes and he didn't do this regularly. So a lot of lawyers out there, including myself, have had to clean up the messes of others. So make sure you get professional help instead of friend help. All right, executor mistake number 10 is ignoring claims against the estate. It is common for people to pass away and have outstanding debts or credit card bills or medical expenses. And oftentimes those creditors will let the executor know that they are due funds from the deceased or from the estate of the deceased. You can't ignore those. I'll just if you ignore those, you might be personally liable for those debts to the extent that the debt is valid and the estate doesn't take care of the debt. So don't ignore debts of the estate. Mistake number 11 is self-dealing. Can't do it. Dad may have had this beautiful BMW that was only a year old. And maybe your thought process is, you know what, I'm the executor and I'm doing this, and maybe I'm due, a little favor from the estate. So I realized Dad's BMW was worth, $50,000, but I'm sure Dad would have liked for that BMW to have stayed in the family. So as the executor, I'm gonna buy that BMW from the estate for $1,000, and then we'll deal with the rest of the assets. That probably won't fly too well, particularly over the remaining 10 years where the other heirs see you cruising around town in that nice BMW that you bought for $1,000 when it could have been sold for maybe $50,000, and that money would have been divided up among the heirs. So there's some major problems with self-dealing as an executor. Don't do it. By the way, as an executor, you're entitled to compensation from the estate. So if you feel like you've earned something special from the estate, perhaps you should accept the executor compensation that you're entitled, which can vary from state to state, and the terms of the will may address executor compensation as well. Last but not least, executor mistake number 12 is handling the tangible assets under your own terms. So, if somebody dies and they have a bank account with $100,000 in it and there's 4 heirs, they're equal heirs, pretty simple. Each heir gets $25,000. But when there's 4 heirs and there's some tangible personal assets, kind of like the piece of furniture over my left shoulder, or the photos of my kids over the right shoulder, or maybe even a really expensive piece of art that hangs on the wall. Even though it's hard to divide up tangible assets, it doesn't relieve you from your responsibility to make sure that things get divided up 4 ways equally. However you do that, perhaps with all of the heirs' participation, cooperation, signing off on everything, that's up to you, whether that's getting things appraised or letting people kind of pick by lots, or just getting the 4 of you to agree. But handling it under your own terms, kind of like, I'm going to take this, or sis, you just go get whatever you want out of mom's house and we'll figure out what to do with the rest. That's likely to cause some problems, and you want to make sure you address the tangible stuff just like you do the financial stuff and the real estate for that matter. So those are 12 executor mistakes. I'll also mention that while you may be appointed or named as an executor in a will, all of these mistakes also apply to someone who is an administrator of an estate. And an administrator is when somebody died without a will and a judge has to appoint an administrator. And same role pretty much of an administrator when someone doesn't have a will versus an executor that was named in a will. So it's just as easy for administrators to make these 12 mistakes as it is for the executor to make these 12 mistakes. All right, make sure you give me a like and a subscribe. It doesn't cost anything. And by subscribing and clicking the notification bell, you won't miss anything as I keep making these educational estate planning videos. We'll see you next time.